Here's a strange fact about the Second Amendment, and it is the whole episode in one sentence. The text has not changed a single word since 1791, not a comma. But the right it protects, the actual enforceable, this is what the Constitution guarantees, right? Almost nothing today like what it looked like in 1939. Same 27 words, different right. That should bother you a little, whatever you think about guns, because if the words did not move, something else did. And figuring out what moved and who moved it is the most useful thing you can know about this amendment right now, more useful than any particular case outcome, because the thing that moved is the method, and the method decides the outcomes. Before we start, one word about what this episode is and is not. This is a doctrinal walkthrough, not a policy argument. I am going to tell you what the Supreme Court has held and how its reasoning changed. I am not going to tell you whether any of it is correct, or what the law should be. That is your business, not mine. This is Do It for the Case Law. Doctrine Deep Dive Season 0, the amendments, one at a time, one sharpest gap each. Today, the second. Start with a sentence because its architecture is genuinely unusual and it is the source of 2 centuries of argument. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Most constitutional provisions just give you the rule. This one gives you a reason and then the rule. Lawyers call the first half the prefatory clause and the second half the operative clause. And the entire 20th century fight over this amendment was a fight about the relationship between those 2 halves. One reading the prefatory clause limits the operative one. The right exists because militias are necessary, so the right is about militia service. Take away the militia context, and the right has nothing to attach to. The other reading the prefatory clause announces a purpose, but does not narrow the right. The right belongs to the people, the same phrase used in the First and Fourth Amendments where nobody thinks it means the people, but only while on government duty. It is worth slowing down on why this is genuinely hard, because it is not a manufactured controversy. English sentences of that construction were common in 18th century legal drafting, and grammarians disagree about what work the opening clause does. If I say the roads being icy, drive carefully, I have given you a reason and an instruction, and the instruction does not evaporate when the ice melts. But if I say a fire department being necessary to public safety, the right of the people to own ladders shall not be infringed, you might reasonably wonder whether I meant ladders generally or firefighting ladders specifically. Both intuitions are available in the text, which is precisely why the argument lasted 200 years and why, when it was finally resolved, it was resolved by 5 votes rather than by the sentence explaining itself. There is also a structural question underneath the grammatical one. The Constitution elsewhere gives Congress power over the militia, organizing it, arming it, calling it forth. If the Second Amendment were only about militia service, it would sit oddly next to those provisions, protecting a thing the same document hands Congress authority to regulate. If instead it protects something the people hold independently, it functions the way the rest of the Bill of Rights functions, as a limit on what government may do to individuals. Neither reading is absurd, that is the problem. For most of American history, the first reading had the upper hand in the federal courts, and the case everyone pointed to was decided in 1939. That case is United States versus Miller, and I want to flag something for anyone taking notes, because there are 2 famous Supreme Court cases with that exact name. The one we want is from 1939, reported at 307 U.S. 174. There is a completely different United States versus Miller from 1976 about bank records and the Fourth Amendment, which we will meet in a different season. Same caption, unrelated law. The 1939 Miller case involved a sawed-off shotgun and the National Firearms Act, and the court's reasoning tied the right to military utility in a way that shaped the next 70 years. Here is the operative passage, quote, "In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly it is not within judicial notice that this weapon is any part of the ordinary military equipment, or that its use could contribute to the common defense." End quote. Read what that does. The question is not whether you are in a militia. The question is whether the weapon has a reasonable relationship to militia efficiency. Lower courts spent decades reading that as a militia-centered right, and for most of the 20th century, if you challenged a gun law in federal court on Second Amendment grounds, you lost. Then, in 2008, the court took the other road. District of Columbia versus Heller involved a district ban on handgun possession in the home, and the court held, for the first time in its history, that the amendment protects an individual right untethered from militia service. The reasoning walks through the text word by word. The people keep, bear arms, and then states the conclusion plainly. Quote, "Putting all of these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation." End quote. And the court left no ambiguity about how firmly it meant it. Quote, "There seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms." End quote. Now here's the part that gets lost in almost every popular account of Heller, and it matters enormously for what comes later. In the same opinion, the court went out of its way to say the right has limits. Quote, "Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose." End quote. And then it got specific, listing categories of regulation it was not disturbing. Quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. End quote. In a footnote, the court added that those examples were, quote, presumptively lawful regulatory measures only as examples our list does not purport to be exhaustive. End quote. So Heller did two things at once. It recognized an individual right and it drew a fence around that recognition. Both halves are the holding. Anyone who tells you Heller says the Second Amendment is absolute has not read past the headline. 2 years later, the court answered the follow-on question. Heller struck down a District of Columbia law and the district is federal territory. Did the right apply against states and cities? In 2010, in McDonald versus City of Chicago, the answer came back yes. Quote, we therefore hold that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. End quote. And more simply, quote, we hold that the Second Amendment right is fully applicable to the states. End quote. That is the incorporation move, and it is the same machinery we saw with Assembly in the First Amendment season, and we'll see again and again a right written against the federal government becoming enforceable against your city council. So by 2010, you have an individual right enforceable everywhere. With an acknowledged set of limits, what you do not have is a method. Heller told courts what the right is. It did not tell them how to decide whether a particular law violates it. The courts of appeals filled that vacuum themselves, and they largely converged on a two-step approach. First, ask whether the regulated conduct falls within the amendment's scope as a historical matter. Then, if it does, apply a familiar tier of constitutional scrutiny and weigh the government's interest against the burden. That second step deserves a real explanation, because its removal is the whole story of the last 3 years. Means-end scrutiny is the ordinary engine of American constitutional law. A court asks how important the government's objective is and how well the challenged law fits that objective. The more fundamental the right, the harder the government has to work. Under the most demanding version, strict scrutiny, the government must show a compelling interest and a law narrowly tailored to it, and almost nothing survives. Under intermediate scrutiny, it must show an important interest and a reasonable fit, and a good deal survives. This is how free speech cases are decided, how equal protection cases are decided, how most of the rights you know about are decided. Notice what that framework lets a court consider. Crime statistics, public safety evidence, whether a narrower law would work as well. Expert testimony, legislative findings. It is an inquiry that takes the modern world as its subject and asks whether this particular restriction is justified in it.
Right.
For over a decade, that is how Second Amendment cases were decided. In 2022, the court threw it out. New York State Rifle and Pistol Association versus Bruen involved New York's requirement that an applicant show proper cause to carry a handgun in public. The court struck the requirement down, but the durable part of the opinion is not that outcome. It is the demolition of the framework. Quote, today, we decline to adopt that two-part approach. End quote. And more pointedly, quote, despite the popularity of this two-step approach, it is one step too many. Step one of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means-end scrutiny in the Second Amendment context. End quote. In its place, this, quote, to justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. End quote. Sit with what that changes. Under the old framework, a government defending a gun law argued about public safety, about evidence, about whether the law was tailored to a real problem. Under Bruen, none of that is the question. The question is historical. Can you find, in this nation's tradition of firearm regulation, something the modern law is analogous to? Interest balancing is off the table. The government's job is to produce history. The court did anticipate the obvious objection that no 18th century legislature regulated things that did not exist. It addressed it in a line worth remembering. Quote, to be clear, analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. End quote. Which sounds balanced. But a standard that is neither a straitjacket nor a blank check is a standard that has to be applied, and the lower courts had to start applying it immediately, to hundreds of laws, with very little guidance about how close an analogy has to be. You can watch that problem surface inside Bruen itself, on the question most likely to touch an ordinary person where you may not carry. Heller, you will remember, had preserved laws forbidding firearms in sensitive places such as schools and government buildings. Bruen kept that category and explained where it comes from. Quote, although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, legislative assemblies, polling places, and courthouses, we are also aware of no disputes regarding the lawfulness of such prohibitions. End quote. So courts may reason outward by analogy from those few settled examples, but New York had argued for something far broader, that sensitive places include anywhere people typically congregate, and law enforcement is generally available. The court rejected that flatly. quote, expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement defines the category of sensitive places far too broadly, end quote. And it drove the point home with an illustration worth remembering. Quote, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department, end quote. So the map has 3 fixed points on one side, assemblies, polling places, courthouses, and a rejected theory on the other, with an enormous unmarked territory in between. Justice Breyer put his finger on exactly that territory. And I want to be precise here because this next quote is from his dissent, not from the court's holding what, in 21st century New York City, may properly be considered a sensitive place. What about subways, nightclubs, movie theaters, and sports stadiums? The court does not say. A dissent is not law, but that one is an accurate description of what the majority left open, and in the years since, nearly every venue on that list has been fought over in the lower courts. 2 years later, the court came back to say they had been doing it wrong. United States versus Rahimi, decided in 2024, involved a federal statute barring firearm possession by a person subject to a domestic violence restraining order. The Fifth Circuit had struck the statute down, reasoning that the government could not produce a sufficiently close historical analog. The Supreme Court reversed, and in doing so it corrected the method in unusually direct language. Quote, nevertheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber, end quote. Trapped in amber. That is the court describing how its own 2-year-old test was being read. It went further, quote, the Second Amendment permits more than just those regulations identical to ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers, end quote. And it restated what the analogy actually requires. Quote, as we explained in Bruen, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin our regulatory tradition, end quote. A modern law, the court said, must comport with those underlying principles, but, quote, it need not be a dead ringer or a historical twin, end quote. So the sequence laid end to end is this. 1939, the right is understood through militia utility. 2008, it is an individual right with limits. 2010, it binds the states. 2022, forget interest balancing, produce history. 2024, not that much history. You have been reading us too literally. It is worth being concrete about what this does to an actual case, because the shift is not academic. Imagine a state passes a law restricting firearms in some setting, a hospital, a stadium, a polling place. Before 2022, the state's lawyers would have built a record, incident data, expert testimony on crowd dynamics, evidence that a narrower rule would not work. The court would weigh it. After Bruen, almost none of that is the argument. The state's lawyers go looking for history. Did the founding generation, or the generation that ratified the 14th Amendment, regulate weapons in analogous places? What counts as analogous? How many examples do you need and from how many states? And do colonial-era rules count? And what about laws that were on the books but never enforced? Those are now the litigating questions, and they are questions about archives rather than about the setting in front of the court. Now, there's a practical consequence worth naming plainly. The party with the better historians tends to have the better case, and historical research is expensive. A doctrine that turns on the density of 18th century regulatory records advantages litigants who can fund that research on either side. That is not an argument for or against the method. It is a description of what the method costs to operate. Before we get to the gap, there is one loose end, and it is bigger than it looks. The amendment protects arms. It never says what an arm is. You might assume that means guns, and in practice, mostly it does. But the court has stated the rule more broadly than that, and it stated it in a case about something that is not a firearm at all. 2016, Quijano versus Massachusetts, a case about a state ban on stun guns. The court did not hear full argument. It issued a short unsigned opinion, and that opinion opens by restating the governing rule. Here it is, verbatim. The court has held that the Second Amendment extends, prima facie, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Sit with what that sentence does. An arm is not a fixed list frozen in 1791. It is anything bearable a person carries, and being new is not by itself a disqualification. Justice Alito, writing separately, and I want to be precise, this next line is from his own opinion, not from the court's. Put the application plainly, stun guns, he wrote, are plainly bearable arms because the term covers any weapon of offense or thing that a man wears for his defense or takes into his hands, carried for offensive or defensive action. That is a genuinely large answer, and it leaves an obviously large question sitting behind it. If the category is defined by what a thing does, rather than by an 18th century inventory, how far out does it run, and who decides where it stops? The court has restated the rule. It has not drawn the boundary. So that is what the case law shows. It is worth asking whether anyone has actually measured what the new method did once it reached the trial courts, because the whole justification for the change was that history would discipline judges better than balancing did. That claim is testable, and it has been tested. The first attempt is a study of the entire first year after the 2022 decision, published in the Virginia Law Review by Eric Rubin, Rosanna Smart, and Ali Rohani Rabar, a law professor and economist at the Rand Corporation and a professor of epidemiology. They coded every Second Amendment opinion they could find in that year, 326 opinions, ruling on 464 separate claims. And I want to name their affiliations because you should weigh them. One author is a fellow at the Brennan Center, which advocates on this issue, and the project was funded by Arnold Ventures. That does not make the counting wrong. It does mean you should look for someone independent saying the same thing. Their finding was that the success rate of Second Amendment challenges after the change far surpasses the rate before it, and that where a claim landed depended a great deal on who heard it. In their words, their findings suggest that the new test has not meaningfully constrained judges, that judicial ideology predicts outcomes even after accounting for the type of law being challenged.
Now the independent check.
Rebecca Brown, Lee Epstein, and Mitu Gulati, writing in the Annals of the American Academy of Political and Social Science, went at it as a straight hypothesis test across federal gun decisions from 2000 to 2023, before the switch and after it. Their conclusion, in their words. The switch from a means ends to a history and tradition methodology corresponds with an increase in judicial discretion, and personal factors like partisan identity shape judicial behavior after the change in ways they did not under the prior regime. Their result, they write, challenges the notion that a historical approach provides a neutral constraint on judicial discretion. That is not a claim that history has no place in constitutional law. It is a narrower and harder claim that this particular test does not run itself. Which brings us to the gap, and it is not the gap you would expect. With most amendments in this season, the gap is between a big-sounding promise and a smaller delivered right. That is not the Second Amendment story. Its right has expanded over the last 2 decades, not contracted. The gap here is about method, and it cuts in every direction at once. The text did not change. What changed is who decides and by what technique. And the current technique makes the outcome of a gun case depend on a historical judgment. How close an analogy is close enough that the court itself has now had to referee twice in 2 years, because reasonable judges reading the same history reached opposite conclusions about the same statute. That is a genuinely unusual place for a constitutional right to sit. It means the answer to is this gun law valid is not primarily a question about guns or about safety or about the words of the amendment. It is a question about whether a court finds the 18th and 19th centuries sufficiently similar to now. Both sides of the policy argument should find something uncomfortable in that, and both sides have said so. And it means that the honest answer to what does the Second Amendment protect today is an individual right, applicable everywhere, bounded by limits Heller expressly preserved, whose contours are being worked out case by case through historical analogy that the Supreme Court is actively supervising. It is not settled, it is being built, right now, in front of us. That is the primer. A full Second Amendment season on this show would take these apart properly, the prefatory clause debate on its own terms, Heller's presumptively lawful categories and what has happened to each of them, incorporation and what McDonald did and did not decide, the mechanics of the Bruen analogy, and the post-Rahimi circuit decisions where this is being fought out right now. One doctrinal question per episode, each anchored in cases we verify, not remember. A quick word on how this show works, and then I will let you go. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do or what to think. And everything is built on real, named, verified cases. Every holding quoted today was pulled from the court's own opinion before a word was written, and you will find every citation in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I will see you at the next amendment.